Hello everyone. In this video, I will discuss the principles of administrative law. Okay, so what comes in your mind when you hear this term, that is principles of administrative law? What it could be? See, in a democratic society, fundamental principles of administrative law are transparency or openness. You don't think so? The principle of participation, of impartiality and objectivity, reasoned decisions, legality, effective review of administrative rules and administrative decisions, accountability and non-arbitrariness. So, did you get these terms or not? As of now, you understood what the role of these administrative bodies have. So, if they performing certain kind of task related to people, okay, that is of course related to the interest of the citizens, people for whom they are doing or exercising their powers, their functions and everything. So if they are making certain kind of policies, certain kind of rules, regulations, so you don't think that those rules, provisions need to be fair, open, okay, impartial, okay, and if something is being said, then there must be some reason behind that, okay, that must be effective, okay. So all those things has to be there in order to make the administration reasonable, okay, and that ultimately ensures the good governance, okay. So all these aspects condensed into three principles. The first one is rule of law, second one is doctrine of separation of powers, and the third one is principles of natural justice. Okay, so please keep patience because this topic is going to be a little longer because we have to discuss all these three principles. But I ensure we will discuss these three topics in brief. So be focused, because these are the core principles of law, but nevertheless I ensure you we will discuss in simple language so that you can appreciate. Okay, so starting with the rule of law. What is meaning of rule of law? What comes in your mind when you hear this term rule of law? Let's understand it. Understanding the rule of law, just we will discuss something, the historical background, because before the democratic society or democratic governance, we had what? Monarchical system. Under the monarchical system, what was the things? Every sort of powers was vested in single man. And who was that? He was the monarch or king, and he exercises every sort of powers. Okay? And whatever he said means said. That has to be obeyed, okay. Hence that system was arbitrary, okay. No one can oppose that. Once king said something, that is said, nothing can be done against that. So over a period in time, as the monarchical system gradually evaporated and the new system evolved in the form of democratic governance, parallelly the rule of law also evolved. So nowadays what we have the rule of law kind of system, right? Okay, so if we have the rule of law, then what does it mean actually? The rule of law is a system, okay, that attempts to protect the rights of citizens from arbitrary and abusive use of government power, okay. So this is the rule of law that protects your interest in case any of the government officials tries to encroach your right. So because of the rule of law, your interest is being protected. So you now got the meaning. What is meaning of rule of law? Okay. The next subtopic under the rule of law we have, that is procedural aspects of rule of law. Okay. What does it mean that? What are the practical aspects of rule of law? Simply. So following are the important practical aspects. Just pay attention. Hearing by an impartial and independent tribunal. that is required to administer existing legal norms on the basis of the formal presentation of evidence and argument. Okay, along with the judiciary we have also tribunals. Okay, so whatever the adjudicatory body is, that is separate part, we won't be focusing on that. Whatever it is, maybe it is tribunal, maybe it is judiciary, maybe it is an administrative body itself. Okay, so whatever it is, but the point that we need to focus is it has to be impartial. Okay, and every parties in that dispute must be given chance to present his or her point. Okay, so that is the purpose of rule of law. Second, procedural aspects, that is right to representation by counsel at such a hearing. So if you are something like accused of any crime or the things and you cannot afford any counsel, then state will provide you the counsel. Okay, or if you can afford, then you have the right to hire a counsel. So if you can afford, then you can hire yourself. Okay, no one can oppose that. Next one is right to be present to confront and question witnesses and to make legal argument about the bearing of the evidence and the various legal norms relevant to the case. You know that because we have already discussed the criminal law. In that we have discussed, while discussing the criminal trial, all these things, you can very well correlate this point with that trial of the criminal cases. So you can very well connect with the criminal trial. Okay, the same point it is being discussed. Last one is right to hear reasons from the tribunal when it reaches its decision, which are responsive to the evidence and arguments presented before it. What does it mean? That if the tribunal, the court or whatever it is, given the judgment, in that case you have the right to know on what basis, on what reason that judgment is given. Okay, so these are the major procedural aspects of rule of law. So now the next subtopic under the rule of law that we have, that is rule of law in the Indian context. By the time, as all of us know, that Article 14 of the Indian Constitution ensures the concept of rule of law, which further strengthened with the evolution of doctrine of basic structure through the landmark judgment given in the case Kesavanand Bharati versus State of Kerala. Okay, besides means Article 14, all other provisions of fundamental rights, including Articles 17, 18, 19, 21, 23, 24, 25, 26, 27, 28, 29, and as such all articles of fundamental rights which I didn't mention here are the part of rule of law. Okay, so you can say the part 3 of the Indian Constitution dealing with the fundamental rights is directly related to rule of law. So the term rule of law suggests that the law itself is the sovereign. Okay, because everyone is bound to follow the law. No one is above the law, and whatever the law says, everyone needs to follow that, irrespective of his position, social status, that doesn't matter. Okay, as an ideal, the rule of law stands for the proposition that no person or particular branch of government, see, not only individual but also government, may rise above rules made by elected political officials. These laws reflect the morals of a society, and in a Western democracy, they are supposed to be pre-established, formalized, neutral, and objective. Everyone is subject to their dictates in the same way. Okay, the rule of law, therefore, is supposed to promote equality under the law. So, law is supreme, not any person. So this is all about the rule of law. So the next principle under the principles of administrative law is separation of powers. So what is meaning of separation of powers? Before understanding that, let's understand how it evolved. Okay, see, the concept of separation of powers evolved on the principle of power can be countered only with power. What does it mean? That if you want to overcome one power, then you need to apply another or greater amount of power on that. So this sentence saying the same thing. Power can be countered only with power. Okay. So on this principle, the concept of separation of power evolved. Separation of powers was meant to create divisions within the government. Okay. Set up to create partition within the state. In this struggle to balance the power, the liberty of citizens is expected to be safe, for separation serves as a guarantee of protecting the life and liberty of people. When power and control lie with more than one center, the opportunity for it to be misused is reduced. So this is the concept. Now I believe you must get an idea about the separation of powers, what it is, how it evolved, and what its benefit is. So now let's start with the meaning of separation of powers. Okay, it will something like further strengthen your concept of separation of powers. Okay, separation of powers means the division of responsibilities among the distinct branches of government, and to limit any one branch from exercising the core functions of another. Okay, the intent of this principle is to prevent the concentration of power in one branch of the government and provide the means of checks and balances. Likewise, one can restrain other in case it exceeds its jurisdiction. So take the example of India. So their power is separated among three organs of the government: executive, judiciary, and legislature. And you know that no one can interfere in each other's work, and if one tries to exceed its power, its jurisdiction, then other will restrain, okay, not to do that. So that is the thing that we have discussed under the meaning of separation of powers. Okay. So now we will discuss something, that is, who was the person behind this beautiful concept. So it was Montesquieu. The modern concept, that is separation of powers, was distinctively given by him. Montesquieu was a French judge, man of letters, and political philosopher. Okay, he was the one who had given the modern theory of separation of powers, as we have discussed, which is implemented in many constitutions throughout the world, either directly or in some modified form. So now I am asking one question, that is, in India, do you find Montesquieu's separation of powers directly implemented or with modified form? Just keep this question in mind and keep listening. Based on the Montesquieu's principle of separation of powers, these two gentlemen, Wade and Phillips, implied three propositions. Namely, the same person shouldn't form more than one organ of the government. So if a person is the member of judiciary, he won't be at the same time the member of legislature. Okay, so at one time he will be the member of one organ of the government only. Secondly, one organ of the government should not exercise the function of other organs of the government. It means judiciary won't make the law. Its duty is only to interpret the law, so it is bound to only interpret the law, not to legislate the law. So one organ of the government won't exercise the function of the other organs. Okay. Lastly, one organ of the government shouldn't encroach with the function of the other two organs of the government. It means simply, while exercising its own power, means I tell you again with an example. While deciding the case, judiciary is only allowed to interpret the law, not to legislate the law. If there is no law on certain aspect or on certain issue, then judiciary can recommend legislature to make the law. So these three are the propositions based on Montesquieu's principle. Okay. Now we will see the separation of powers in Indian context. Remember the question that I asked? Keep in mind, you will get answer here. So based on the above discussion, can we say that India follows Montesquieu's theory of separation of powers? In first instance, answer is what? No. Because if we take the example of the United States, the president doesn't sit in the Congress, But in case of India, not only the Prime Minister, rather along with his cabinet, freely participate in the legislature. And if we go through the proposition that we have seen there, one person cannot be the part of other organs of the government. Right. Likewise, theory of separation of powers is not applicable, but we cannot say it directly because India has the such system of separation of powers, but in the modified form or flexible form, not directly, which is a little different from the Montesquieu's theory. I believe now it is very much clear with you. It is true that the theory is explicitly not mentioned in the Constitution of India. This is another fact. But the doctrine of separation of powers is a part of the basic structure where one branch of the government has the power over other, provided it crosses its limit. So if legislature does something that is beyond its jurisdiction, then judiciary comes into picture and restrain the legislature. Okay. Besides, the judiciary has the power to void laws passed by the parliament. This is another fact. In case that legislated law is unreasonable or unconstitutional. Further, judiciary can declare any of the actions of executive unconstitutional and hence void if it doesn't fall under the purview of the constitutional framework. Okay, so this is how checks and balance. Okay. Moreover, both the rule of law and the separation of powers together play a major role and establish that administrative law is not an exclusive domain of the executive. In fact, it is applicable to each branch of the state. So now we have the last principle of this topic, that is rule of principles of natural justice. No bias and right to fair hearing. Okay, what does it mean? Principles of natural justice, which of course are not fixed rules, but they are significant flexible principles. Pay attention that it is not fixed, rather it is flexible, which can be molded to suit the requirements of a particular situation or a specific purpose to do justice in any particular case. So depending upon the case, the principle of natural justice can be customized, designed. Okay, so that is the integrity of natural justice. Now let's understand what is the meaning of principles of natural justice. So principle of natural justice derived from the expression just natural of the Roman law doesn't have force of law as they may or may not form part of a statute, but they are necessarily to be followed. These rules are intended to prevent such authority from doing injustice. So here we have two aspects. That this rule is not part of the principal rules or law, not essentially. Nevertheless, a statute has to follow that. Okay, because as we have discussed above that it is not fixed, rather it is flexible. So it is not written. If it is written means it is fixed. Not written means it is flexible. Okay, and secondly, what is that? These rules are intended to prevent such authority from doing injustice. So justice has to be done fairly. Okay, and this principle, that is principles of natural justice, ensure that. Further, the rules of natural justice as discussed do not supplant the law of the land. Then what? Rather, it only supplement it. Okay, it not supplant, rather supplement it. Okay, in the case of A.K. Kraipak versus Union of India and in Menka Gandhi case as well, the court said that it is now formally established that in the absence of expressed provisions in any statute dispensing with the observance of the principles of natural justice, such principles will have to be observed in all judicial, quasi-judicial and administrative proceedings which involve civil consequences to the parties. See, it included everything: judicial, quasi-judicial and administrative proceedings. Okay, so it has to be there while deciding the case of any sort, any dispute. So principles of natural justice. What are the principles now? following are three major principles of natural justice. The first one is nemo debet esse judex in propria causa, which means nobody shall be a judge in his own cause or in a cause in which he is interested. This principle is more popularly known as the doctrine of bias. Okay, so if some person who is involved in something, in some dispute, so he shouldn't be the judge of that committee because it is against him only. So someone else will preside that committee, okay, in order to ensure the fairness. Next principle is audi alteram partem, which means to hear the other side. What does it mean? This is necessary for providing a fair hearing, and no doubt the rule against bias would also be a part of the process. Means if someone is putting some allegation on other party, it doesn't mean that based on his statement or some even with some proof you are supposed to be deciding the case. No, you need to also hear the other side, means the other party who is being accused in this case. He must be given the chance. Okay, that is another principle of natural justice. Lastly, speaking orders or reasoned decisions, which means giving reasons for a certain decision, is one of the fundamentals of good administration and a safeguard against arbitrariness. Means, of course, if someone decided something, then on what basis that decision is being given, that must be substantiated with the reason. Okay, so these are three principles of natural justice. Okay, so while developing the administrative law, such principles of natural justice are taken care, and hence a third rule of transparency and reasons can also be added to the rule against bias and the rule of fair hearing. Okay, so this is all about the principles of administrative law, where we have discussed the meaning and three principles, that is rule of law, doctrine of separation of powers, and principles of natural justice. Okay, I hope you must understood, but I have not, because this topic is highly conceptual and lengthy. So I request all of you watch it at least 5 times. Okay, however, if you have any question, you can always ask through the comment box given below. Wish you good luck and see you in next video.